debate, the honourable member for Nepean.
Thank you, Madam Speaker. Honourable colleagues, I rise today to speak about Bill C-27. I will focus on Artificial Intelligence and Data Act, but before that I would like to briefly talk about the overall Digital Charter Implementation Act. Canadians have never been more reliant on the digital economy. Yet, the current privacy law was last updated over 20 years ago, before iPhones or Facebook even existed. In the new digital economy, enhanced privacy will not only benefit consumers, but will allow companies to innovate, compete, and thrive. We are now at a juncture where over the next few years, the rules of the road for digital privacy and AI are being written and entrenched. That is why it is crucial to have clear rules when it comes to this sector. For Canadians to prosper and benefit from the digital economy, they need to have confidence that their data is safe and trust that their privacy is being respected. That's why the government has introduced this legislation that will ensure Canada has critical protections in place. Bill C-27 will ensure that Canadians have first-class privacy and data protection, and that companies that break the rules face severe consequences, some of the steepest fines in the world. It will also hold organizations to a higher standard, in particular when it comes to protecting the personal information of minors by giving them and their parents more power over their information, including the ability to have it deleted. With C-27, we are moving beyond traditional privacy protection to ensuring data control for all Canadians. Canadians can be reassured that we will never compromise on trust and safety of their privacy. Over the last decade, artificial intelligence technologies have been expanding rapidly and have benefiting Canadians in varieties of ways. These technologies are evolving rapidly, and with that, there is an increase in risk and harms due to the use of AI systems, whether intentional or unintentional. The Artificial Intelligence and Data Act, AIDA, would establish rules to promote the responsible use of AI and the related governance practices. The framework would ensure the development of AI systems that has to include plans to mitigate bias and harm, and that organizations are accountable for their practices. The AIDA seeks to regulate international and interprovincial trade and commerce in artificial intelligence systems by requiring that certain persons adopt measures to mitigate risk of harm and biased output related to high-impact artificial intelligence systems. The Act provides for public reporting and authorizes the Minister to order the production of records related to artificial intelligence systems. The Act also establishes prohibitions related to the possession or use of illegally obtained personal information for the purpose of designing, developing, using, or making available for use an artificial intelligence system in an intentional or reckless way that causes material harm to individuals. This will ensure that Canadians have strong privacy protections and clear rules of the road for business, as well as guardrails to govern the responsible use of artificial intelligence. This bill will provide Canada with adequacy within the European Union's GDPR framework and international interoperability on privacy. Further, it will enable Canada to remain on the cutting edge of artificial intelligence development. This bill will help us to build a Canada where citizens have confidence that their data is safe and privacy is respected, while unlocking innovation that promotes a strong economy. University of Toronto's Swartz Reisman Institute for Technology and Society studied this bill And I would like to quote from an article written by policy researcher Maggie Arya. Quote, as technology continues to advance and permeate almost all aspects of modern life, it has become necessary for regulators to grapple with how best to regulate it. New ways of collecting and processing personal information necessitate new regulations to protect those whose information is being collected, analyzed, and sold. Often, whenever they visit a new website or sign up to a new app like Facebook or TikTok. Advances in artificial intelligence are also top of mind for many regulators, posing unique risks and challenges that must be addressed. The recently tabled Bill C-27 represents Canadian regulators' efforts on both fronts. The Artificial Intelligence and Data Act is the federal government's first attempt to comprehensively regulate artificial intelligence. Canada is not alone in this. AIDA comes in the wake of similar initial attempts at AI regulation by other governments around the world, such as European Union's 2021 AI Act and the United States 2022 Algorithmic Accountability Act. AIDA, like the EU's AI Act, takes a risk-based approach to regulating AI. However, it is worth noting that Canada proposes categorizing AI based on whether it is high impact, while the EU uses the language of high risk. AIDA is also far less prescriptive than the European Union AI Act. The draft act is quite short, with much room left for the enactment of provincial AI laws, as well as further federal regulation. A person becomes a person responsible for an AI system if they design, develop, make available for use, or manage the operation of an AI system in the course of international or interprovincial trade and commerce. The major requirements contained in AIDA for persons responsible for AI systems include ensuring the anonymization of data, conducting assessments to determine whether AI system is high impact, establishing measures to related risk, monitoring and keeping records of risk mitigation, and requirements for organization to publish a plain language description of all high-impact AI systems on a public website. If any time the minister has reasonable grounds to believe that a person may be in contravention of these requirements, the minister may order that person to conduct an audit to the responsible contravention or engage an independent auditor to conduct the audit. The tabling of Bill C-27 represents an exciting step forward for Canada as it attempts to forge a path towards regulating AI that will promote innovation of this advanced technology, while simultaneously offering consumers assurance and protection from the unique risk that new technology poses. There are sections of C-27 that could be improved, including areas where policymakers could benefit from the insights of researchers with domain expertise in the areas such as data privacy, trusted computing, platform governance, and social impacts of new technologies. To ensure that the powerful new technologies that shape our world today benefit everyone, it is essential that our policies are well informed, especially when it comes to how technology systems work, how they interact with our legal infrastructure, and how they impact society. As we approach the implementation of this landmark regulation, it is critical that Canadians are engaged and informed on these topics and ready to make their voices heard. End quote. I will now quote from an article written by law firm McCarthy Tetrault. Quote, Bill C-27, if adopted into law, is set to have a significant impact on businesses by creating new requirements for those who make, use, or work with AI. The bill imposes several new obligations on the AI sector, which are backed by serious penalties of non-compliance. Thank you, Madam Speaker.
Questions and comments? The honourable member for South Shore, St. Margaret's.
Thank you, Madam Speaker. I listened intently with the member Nepean's speech, and I noted at the beginning that the member talked about the issue of children, and the minister went on about that in his opening speech. And this bill is 124 pages. You know how many times minors are mentioned? Once. Doesn't define what a minor is and says minors or information is sensitive, and it doesn't define what sensitive is. So perhaps a member of the Liberal government could define for this House what a minor is under this law, or this proposed law, and what is sensitive information as this says in the definition section.
Member for Nepean.
Thank you, Madam Speaker. There are two things here. One is definition of minor. I think there are well-recognized legislation and adopted by various authorities and institutions who a minor is. I think that will be applicable here. On the second definition of sensitiveness and other definitions related to these fast-changing technologies, Madam Speaker, my view is that we should not cast in iron in the legislation the definitions of various things that are involved here, but leave it to the government and the regulators going forward have the flexibility to define the various terms that are used in this legislation. Thank you, Madam Speaker.
Questions and comments? L'honorable député de Terrebonne.
Merci.
The honourable member for Terrebonne. Thank you, Madam Speaker. I'd like to thank my colleague. I'd like him to answer this question. Doesn't he think that since Quebec already has its own legislation that works very well to protect personal data, doesn't he think that it should be set out clearly in Bill C-27 that it will not contravene the law that already exists in Quebec? It should be set out clearly and stipulated in the bill.
Speaker, it's right that Quebec has an existing law, and this law does in no way impede the Quebec's ability to promote and act on its own law. In fact, this legislation will enable Quebec and other provinces to move forward with any changes they may need to improve their own laws to protect the privacy of people. Thank you, Madam Speaker.